agreement. So today we're just going to do a high-level overview of the harmonized practice rules that go into effect on April Fool's Day. Just give you a little bit of background. So going back, this process actually started in August 2013. So your board leadership, along with other board leadership, so that involves like the president, CEO, some people from the board of directors, have a leadership meeting at the area level and said we need to have consistent rules throughout the province so you can go around from anywhere in the province and trade in real estate and have the same rules. And so that's when that started. Finally ratifying in November 2015. So just last year, we finally met agreement on all of the rules. And we were the last board to adopt it. There was a couple of rules, one of them we'll talk about later, that our board of directors just needed a little bit more clarification on before they approved it to go forward. And of course, because of that, we decided that we were going to wait until April 1st to actually implement them. We wanted to give you an opportunity through all those lovely emails that you get weekly to become familiar with them, because there are some changes from what maybe you're used to in our current rules, although they are a lot of common courtesy items that are in there that maybe you probably already practice in that way. So all of these rules also went through legal counsel. They went through the Canadian Real Estate Association as well as RECA, and you'll notice throughout the rules it says unless otherwise instructed by the seller. That is directly related to how RECA's position is as far as always follow the instructions of your client. So you'll see that throughout the rules. So we had this vetted through them as well. And our board of directors, of course, approved it. We did eliminate some rules as a result because there was overlap. And it was an opportunity as well for our Arbitration and Professional Standards Committee to look at some maybe outdated rules. And so some of those are being eliminated as well. Going forward, if we want to make any changes to these rules, it has to come from a committee to the board of directors and then be something that goes through the change process where all other boards have to agree. So if there's something that's really urgent, then they'll meet and deal with that. But if it's, you know, hey, this isn't working, then that'll probably be dealt with whenever their meeting is. So I expect that potentially could be an annual thing where we would go there and try to reach agreement on a change to the rules. So on Friday, the full rules package will be available to you. It might even be available between now and Friday. All the information is just sitting in another department right now. So it will contain the MLS Harmonized Rules. It will contain the Harmonized Practice Rules in the province. It will have our RAE specific rules, and I'll go over that at the end as far as what's specific to RAE. So let's just get started. Professional conduct. So this isn't anything new. We all are supposed to be treating each other with respect. Actually, the code tells you to do that. The difference with this rule for us is the fact that it adds area. So area now has adopted these rules themselves so they can enforce them if need be. As well as it involves people, staff at the board. So obviously being abusive to staff at the board is not going to be tolerated. So this has been added. That's the difference. Really respect each other. That's all it is. Duty to resolve issues. This is new for us as far as written complaints. So typically in the past, we would encourage you to resolve the issues between, or tell you to talk to your broker and have the other broker talk to the other broker when it was dealing with professional conduct. Now, you have to actually try to work it out before you send it to the board. So that's a little bit different than maybe what you're used to. I suppose if something comes into the board, obviously haven't practiced these rules yet, but if something came into the board and there was no willingness from one side to cooperate or deal with it, then the Professional Standards Committee would look at that and determine whether they could move forward. Advice constraints. This isn't really new. It's new to our rules, but really it's in all of your contracts. It's also in Article 10 of the Realtor Code. Really, you're not supposed to be giving advice outside of your scope. So you're not accountants. You shouldn't be giving GST advice and things like that. So this is just a reiteration of that. Solicitation of associates. This isn't new either. Obviously, in this room, you shouldn't be trying to recruit other people to your brokerage. The same as any other board organized event, or so, you know, at the ball or all of those different functions, you shouldn't be doing that. That's not new. So it's just reworded a little different. Using board web resources. So this would be like the member feed on Facebook and things like that. We've actually had members out there that are recruiting using those tools. This is new for us. We've kind of practiced it, but we've never had a rule to enforce it. So typically we would alert them and say, hey, you shouldn't be doing this. This is not allowed. Now we have a rule that says you can't. So if somebody, I guess, wanted to pursue that, and they could do that. Sending recruiting materials. You cannot use another brokerage's delivery system to recruit people. So an example of that, the one that I've used that seems to make sense to me, is maybe even not necessarily in writing, but even making a phone call and using the services of the answering service. So if I'm just going to pick on Sheldon because I think he was picked on at another meeting. The telephone answering service. So if Sheldon was to call there and leave messages for all the different agents and try to recruit them for the purposes of recruiting, and that another brokerage, maybe Gladys's brokerage, was paying for that service, that's considered a breach. So basically, there's nothing wrong with calling an individual realtor and you know, talking to them about that, but you shouldn't be using that other brokerage's resources to recruit. Again, I don't know what this is going to look like when it comes out on the back end and where we're going to go with that. Somebody would have to be able to prove that, you know, obviously if it was Gladys's office, hey, this cost us like $1,000 because this person kept calling and all of my people are telling me that they're trying to recruit her. Solicitation of potential clients. So basically, you're not supposed to be soliciting other people's clients. If you know they're in a written service agreement or you know that they're on the MLS system, you're not supposed to use the MLS system data to recruit them. Or if you know that they're in a contract, you're not supposed to be doing that. This isn't new. I believe the only difference here is it's kind of added buyers to the equation. Advertising for potential clients. Every time you are sending a mailer out, this isn't new, you have to have a disclaimer on there that says that you're not intending to solicit or induce breach of an existing agreement. Okay, so any kind of advertisement that you send out door to door, however you do that, it has to be on there. And you're doing a general distribution in a neighborhood. I mean, if you're directing it specifically to people that you have an existing relationship with or that you've had, you know, but you should have a disclaimer on everything. It's just one little line. It just saves you a whole bunch. If there's an issue where somebody doesn't include a disclaimer in their advertising or in their mailouts, and that consumer ends up canceling or breaching their existing agreement to work with you, then that constitutes a breach under the new rules. So please just include a disclaimer and then you're pretty much covered. And obviously if you're walking a neighborhood and you see a sign on a lawn, you ought not leave something at that door because you're targeting. If it's a third party, so they're mailed out or it's a general distribution or anything like that, that's fine. But if you're a licensee and you are walking a neighborhood and door knocking or doing something like that and you see a sign on the lawn, then you shouldn't be approaching them. Solicitation of contracts. So suggestion for buyers to view properties with other members. This is a very common concern in rural areas. I know it's been a discussion at our professional standards committee level as well. Ultimately, you are in a written service agreement with your buyer because it's mandatory now, assuming that you're working with them as a client. So you have an obligation to represent their interests, which means you should probably be showing them the properties that you're going to potentially write an offer on and not sending them out to somebody else to see the property and then come back and write the offer. I mean, obviously, they're in a written service agreement. You're supposed to look after them. And so what was happening in these scenarios where people were sending them out to, I'm just going to use a community, just say Lac St. Anne, they were sending them out to Lac St. Anne and saying, just go look at some properties with Leanne and then come back and we'll write an offer. Well, obviously Leanne's going to try to help them as best as she can because she's working in the interest of her seller, but they're not really working in the interests of their clients. So you can't really tell them to go there and come back and write an offer. You're actually breaching your agreement or not representing them. It's also now a rule. Open house is completely different. It's not an open house is a completely different scenario. Obviously, if they end up enjoying it or thinking it's a great thing, maybe go back and look. Communication notices and correspondence. So this just clarifies the obligations of brokerages to update the board when they change their address and emails. This isn't, I mean, it's new as far as our rules are concerned, and it is very similar to the Real Estate Act. Communication notices and correspondence. So any notice of service by the board is now deemed delivered on the first business day after delivery. So this is a common practice. This is how we kind of dealt with things in the past. It's just now part of the rules, and we've added area to the equation so that they can deal with that if they're sending notices as well. Communication notices and correspondence again. So this rule reinforces our current email policy that we have. And just, you know, there's an expectation if we're communicating with you and maybe dues or something like that, that there's a response if there's a particular time that you should be responding. Spam. So this is new for us, although common practice when I receive a phone call or our department receives a phone call from an industry member that's upset because another member won't stop spamming them or sending them emails about new properties and things like that. You know, give them a courtesy call and let them know, hey, take me off. And hopefully they have an unsubscribe mechanism. It's actually against the anti-spam legislation. The only time you really should be able to communicate with anybody under anti-spam is to, you know, if you're dealing with a transaction or things like that, so with a fellow realtor. But otherwise, you shouldn't be spamming other members. So this rule basically just says, you know, if somebody asks you to stop, you should stop. Advertising requirements, obviously all your advertising has to comply with every single piece of legislation out there. That's all this says. It's not any different than anything that exists in our realtor code, etc. And there's a lot of crossover. Advertising listings of other members. Right now, if you're going to advertise a listing of another brokerage, you need a permission of the listing brokerage and by extension their seller to advertise that property. So that would be in any kind of print form or any kind of social media or anything like that. Okay, that hasn't really, RECA, those are the rules that are under RECA as well. You're not supposed to be advertising unless you have permission to do so. So the only time that there's an exception to that, and many of you are probably familiar with this, is when you have, it's called the IDX VOW, or Internet Data Exchange Virtual Office Website Rules that we have. It's a broker reciprocity. So on your websites, many of you have other brokerages listings on your website, and as long as those comply, because it's a data feed, you may be working with Redmond or Real PageMaker or whatever, it's a data feed, and it will actually show the name of the listing brokerage and the name of the listing agent, and it's supposed to be prominent. So those are what the rules require if you're going to do that, and it's only on those scenarios on a website where you're in a broker reciprocity situation. But otherwise, any other print ad, you're putting things up anywhere on social media, you're not supposed to be doing that if you don't have that listing. Within your own brokerage, it's okay. Advertising a sold listing. If you're going to advertise a sold listing, you need the permission of the current owner. Okay, so basically, if you are the listing realtor, you can advertise that listing as sold. Once possession takes place, the buyer's realtor can advertise that as sold. It's not really different. It's kind of what we've had all along, and it's all common sense. This is the one that caused a little bit of issue at the board of directors. Advertising address and price of sold property. So basically, when you want to advertise, hey, I just sold this property at 123 Cherry Lane for $100,000, you're identifying that consumer. And so because of that, the Privacy Act says you need permission to do that, okay? So if at any time you want to include an address and the sale price when you're advertising a sold, then you need permission of the owner to do that. The exception in here only deals with that period of time when you have unconditional offer to possession. So in that period of time, that contract hasn't closed yet. And so if you're going to put that out there, then you're going to need the permission, and say you're representing the buyer, you're going to need the permission of the seller and the buyer to actually put a sold card in the mail with those details. It's only when you include the address and the sale price that you need that. Sending out a card that says just sold is fine. It's when you identify the property and the price that you need to go further. Inaccurate or misleading advertising. So typically we didn't deal with that. We referred a lot of that to RECA. Otherwise we educated at the board level. And so now, we have a rule to deal with that. So if we have formal complaints that come through the board, we have the ability to deal with that at our professional standards committee level. Buyer accompaniment at showings. So similar to our current rules, the buyer should be with somebody at a showing. They shouldn't be going through the house with their 10 children or family members looking at a property. You should always be with the buyer when you're showing a property. It's not any different than what we're doing now. We've had cases in the past where they've even handed over their keypad to open the door, and a whole van load went into the house and looked at the house, and the listing realtor lived next door. It doesn't look very professional. Okay, and that is a common complaint here at the board. We have lots of complaints about people bringing too many people to the showing and wrecking the seller's house. I mean, just think about it as your own property, and make sure you're with the buyer and there isn't too many. Maybe even have a conversation with the buyer about who's going to attend the showing. You don't want to have, you won't be able to keep control if you have 10 kids in the house or something like that. And of course, the only exception to that rule would be unless otherwise instructed by the seller. Making and keeping appointments. So this is new for us, but it is a common complaint. You may remember, I don't know if it was last year, or maybe it was 2 years ago, where we did a little bit of a campaign to find out what kind of concerns were out there as far as showings and appointments and things of that nature. When you make an appointment, you should be keeping it. If you're not going to keep it, you need to call the other realtor and let them know. Same if you're the listing realtor. If you're going to cancel an appointment or somehow something's happened and it has to change, you need to let the realtor know. We need to be professional. We're representing our clients. There's been a couple of cases that have come through that relate to some clients, the sellers who, they're in a wheelchair and it takes them a lot to get ready to get out of the house so that you can have that showing, and they're across the street or they're down the road in their car watching and nobody shows up. So that doesn't reflect well on the industry. I mean, obviously you're representing your client. I would take the opportunity right then and there to call the listing realtor and say, just so you know, we drove by the house. My client's not interested. We're not going to go in. Can't change that. If they've decided, I don't like this, this isn't what I thought it was. It's a way of communicating, right? You communicate to the listing realtor, sorry, but they didn't like the property. They just looked at the outside and they didn't even want to go in. They can pass that. They can call their client and say, sorry. Inspections. So the buyer's representative must attend an inspection unless otherwise instructed. First of all, somebody has to let them in the house. Inspectors here don't necessarily have access to our key box system. I understand some appraisers do, and this created a question at our professional standards committee. So I just want you to keep in mind that when these rules were created, they were created for all of Alberta. So in some jurisdictions, inspectors have access to key boxes, and some appraisers have access to key boxes. So I hear and I understand that there's members out there that say that you don't necessarily facilitate an appraiser in when they're going in and doing an inspection to do an appraisal. That's fine as long as there's some kind of instruction and communication flowing to the listing realtor to let them know, I've got the call from the appraiser. They're going to go into the property, and making sure that you're keeping those lines of communication open. Otherwise, you should be accompanying your client in an inspection, not following the inspector around. And another good point to make, if you haven't noticed, RECA actually publishes a great article on inspections that helps set the expectations for the seller as far as who's going to be in attendance and what that looks like. So having that conversation as a listing realtor and having that conversation as a buyer's realtor, hey, you know what, it may not be a good idea during the inspection to bring all of your children or all of your family members. It's really just about having the inspection And so that sets the tone. Everybody knows who's going to be there and respecting the property. Essentially, it says that the buyer's representative must attend the buyer, but it comes down to, as far as the appraiser, there has to be a member in attendance, right? So if you're not typically in attendance with an appraiser, because they have access to the system, then you should be having that conversation with the listing realtor. I would just let the listing realtor know that the buyer needs an appraisal done on the property, and they're looking at going in on this day. They have access to the keypad. Make sure that you just cover your butt. All it is about keeping the lines of communication open and respecting the seller's property. If it's an inspector, there's an expectation that the buyer's realtor is going to be there. Inspectors here do not have access to the keypad system or the key box system. So you shouldn't be going into a property in an appraiser situation. Then as the buyer's realtor, you're getting that information from the appraiser. You're passing that information and keeping the lines of communication open with the listing realtor and letting them know this is what's happening. I'm sure there's not going to be an issue with that. Responsibility to secure the property, that hasn't changed. You always have to secure the property. If you open windows, you close the windows, etc., etc. Keys and key box system, the only major difference is the fact that we've added keys to the equation. So basically in the past, our key box rules, they didn't even deal with the keys. So if you're going to take a key, you should never copy a key. I'm sure that you don't do that, but you're not allowed to copy keys. Remember that your sellers entrust you with the keys. I know that there's a potential situation out there in some brokerages where they even give keys out in advance of possession in what I guess they call it in trust. They have some kind of letter. Ultimately, your seller hasn't really approved that, and we've had some complaints from sellers where buyers have gone in and made changes to the property and started, and then what happens if it doesn't close? Like, there's all sorts of liability issues. So if that's a practice in your brokerage, you may want to have a chat with your broker if you're not a broker about potentially seeking the advice of or the instruction from your seller to make sure it's okay and not just doing it between brokerages. It creates an issue at REAX. There's all sorts of liability issues associated with that, and because people don't necessarily abide by that, it's a good practice not to hand them out early. Signage, the name of the brokerage is supposed to be on your sign. It's not anything new. You're supposed to have your name and of your brokerage on your sign in any kind of signs that you do, any advertising. The difference here is now there's the possibility that a seller may have their own sign on their property with their own name in scenarios where you have a seller's rights reserve listing, perhaps. I know it exists. It already exists out there. Signage removal, in line with our key box rules, which require you to remove a key box within 5 business days of expiry, etc., or if it's sold, the signage should be removed at the same time. Interference with signage, you shouldn't destroy other people's signs. Ultimately, if there's an overlap between, listings, maybe it hasn't even gotten to the 5 days or something like that, and somebody else's sign is still on the lawn, but it's clearly expired or terminated, then, you could put that to the side of the house and let the listing realtor know. Just listed doesn't mean 8 months ago. Price reduced, so they basically put a timeline here. I'm not sure if it's sufficient, so we'll see how this goes, but they've said that, within 10 business days, it's no longer a new listing. Okay, so you have a couple of weeks to call it a new listing. Placement of sold signage, again, you need the permission of the owner to do that. Typically, that's already dealt with in your listing contract. You're allowed to do that. As a buyer's agent, you want to make sure that the new owner gives you that permission as well if you want to put your sign on there after possession. The offer to purchase, communication information in the accepted offer to purchase. There's a lot of people, and I believe it's Section 12, that don't fill out Section 12 of the contract that allows you to communicate your offer. Okay, so that's your brokerage, the agent name, your address, your fax number, your email, all of that, the listing and the buyer's brokerage, that should all be there. Okay, the name of the buyer, the name of the seller. You'll be happy to know that the new purchase contract that's coming out is no longer going to contain all of the details and email and contact information of the buyer or seller. The new residential purchase contract hopefully will be available come August, and there will be lots of information sessions and explanatory forms to help you through that process. And the conveyancing page is gone, which is really awesome, that last page. I think we've had some issues with that when AREA created the added that to the contract, it was to accommodate electronic communications, and they maybe went just a little bit too far, and it's actually created some issues where buyers and sellers are contacting each other and trying to cut the realtors out. And so they are removing that information, and it'll just be, you can put the buyer and seller's names, which are already on the contract anyway, so it's not going to cause any issues. Presentation of offers to purchase. This doesn't, you should be presenting offers as soon as possible. As soon as you can get a hold of your seller, you should be presenting all offers. This is just saying you need to do it within 2 business days. Obviously, you need to follow the instructions of your client and all of that as well. They've just put a timeline on here to say, past that, if your seller is not available, which I find highly irregular in today's time and age, then so be it. But just make sure that you're keeping those lines of communication open with the other side. Notification of multiple offers. The only thing that's been removed from our multiple offer rules relates to court orders. So in our old multiple offer brochure, it said if there was a court-ordered listing and they wanted you to participate in a bidding war where you're exchanging all the offer to purchases, that you couldn't follow that. I think that's in contempt of court. So that's been removed, but everything else you still have to disclose that there's multiple offers unless otherwise instructed and there's no conflict of interest. You still have to disclose the name of the brokerage and agent that are representing the other offers. Conveyancing. So basically, there's a clause in here that I've included that will be in your new purchase contract dealing with conveyancing. Who's going to be handling and sending the paperwork. I know there's been some changes between typically it's been in our marketplace the listing brokerage, but sometimes it's a buyer's brokerage. So just handling that in the offer so everybody knows who's going to be taking care of conveyancing, okay, and the instructions and information to the lawyers. So fee payable, there's no difference here. They're basically, the person that writes the offer gets the cooperating commission that's posted on the system. And the only time that would deviate or change is if there's unethical conduct. So if you deliberately interfered in a buyer contract or something like that, then potentially that could be a dispute at the board for commission and unethical conduct. Okay? Otherwise, whoever writes the offer gets the commission. It's all negotiable. I mean, ultimately, you could negotiate it, and I know that it's happening out there because you obviously have a buyer's contract, and sometimes you're getting paid less what's on the system. So obviously that's a conversation you need to have with your buyer first, because you can also get your buyer to pay you. So we actually have a bulletin online that kind of helps you or walks you through that in cases where you're dealing with like a mere posting where you're not getting paid any substantial fee. Payment of fees. So basically you still have to pay the posted rate of commission within 10 business days. That hasn't changed. The only difference in our rules now is that now it contemplates the potential of a buyer's brokerage holding the money and paying the fee. So when there's a shortfall situation, this is really new for us. Basically, if the seller's brokerage is found to not conducted their due diligence, maybe they didn't pull title and realize there was some major issues there and they only ended up getting $5,000 out of the deal and they owe $10,000 to the other side or anything like that, then potentially that would be a breach of this rule. So the brokerage would be on the hook and responsible if the listing brokerage was deemed they didn't do their job. Obviously, if there's no fault on either side, no one could have anticipated that, there was nothing there that showed that, then the two brokerages, there's kind of a process here that's set out for you to try to resolve that now. If you need any information on low equity sales, I do have some great information bulletins that are no longer posted on AREA's website. Receipt of offers to purchase after listing expiry. So this is a little different than what we're used to. So ultimately, I know it's a common courtesy thing where realtors out there, when a listing just recently expired, maybe you've seen the property with your buyer before it expired, and now you want to write an offer. A lot of realtors ethically feel like they need to call the former listing brokerage. This rule kind of confirms that. Call the former listing brokerage and say, hey, I have a buyer that is really interested in writing an offer. So what they've accommodated in here is they've talked about the holdover period. You talk to that listing realtor and say, hey, do you have a holdover period? Because we viewed this while it was listed. Can you protect me for my fees? Ultimately, if they confirm that they have a holdover period, then you can go ahead and present the offer through them and everything should be fine. Ultimately, they'll still be held responsible to pay that fee if they didn't necessarily tell the truth. That would be something that would come to the board. If they don't have a holdover period, and this is something that we've seen a lot on our files, is people are writing up their contracts and they're not filling in the blanks, or they're putting 0. That's not going to protect you. Make sure that you talk to your broker and see if there's a policy around what time frame you might want to put in that section. So it also says that if there's no holdover period, you can contact the seller directly with the offer. Some rules that aren't captured by harmonization and became RAE specific: recording devices, that deals with recordings and hearings. You shouldn't be recording a hearing if you're ever part of a professional standards hearing. Obviously, we have the Real Estate Weekly newspaper advertising rules that are remaining. Yega's home advertising rules that are going to be remaining for just a little bit longer. Our IDX vow rules, and then we also have rules around virtual staging and enhancing. Those actually came into effect during this harmonization process, so hopefully we'll take that to the next meeting of that group and try to get them to adopt it provincially. Okay, so in your brokerage, and then you have somebody in another brokerage. So if your seller says, and you've explained to them the pros and cons, and you've gotten other offers from other brokerages, and your seller says, I do not want anybody to know, and I would cover your butt and get it in writing, I don't want anybody to know they're in multiple offers, then you must follow the instructions of your client. The only time that you cannot do that is where you're in a conflict of interest situation. So that would be, an example of that would be if you're representing a buyer in a multiple offer situation as an individual. Or if you work in a common law brokerage and you're the listing realtor and somebody else in the brokerage is the buyer's realtor for one of the offers. That's a conflict of interest. You cannot follow their instructions. Okay, well, thank you very much. I did have a handout for you, and hopefully that breaks it down further.